Yeah.
Well, welcome to Brooklyn Law School's Environmental Law Society's second career opportunity event. And I really wish to congratulate the Environmental Law Society for organizing this program and providing an opportunity to explore the practice of environmental law. We're fortunate in having a very strong, active bar participation litigation panel this evening. My name's Joseph Camming, and I'm an adjunct professor here at the law school, and I'm standing in moderator for George Johnson, who unfortunately was called away from this event today. Given the fact that our panel is so strong, I think we're well served for allowing them the opportunity to explain the actual practice of environmental law and the opportunities which are available for you in that practice as careers or as those who participate inferentially in the pursuit of other careers. Our first panelist who will discuss this practice and your opportunities is Stephen Barshaw of Sive, Paget, and Rizel. And that firm has been a leader in environmental law after really inventing the practice of environmental law with the Consolidated Edison and the Storm Mountain case. Stephen?
Good evening, everybody. Can you hear me? Is this thing on? Actually, I'm not even sure if it is or not. Does it make any difference if I do? All right. Little bit about our firm, and then something about me, so you'll understand a bit how the two came together. Sive, Paget, and Rizel, as was alluded to, is, according to my partners who were around before I was, is the oldest environmental law firm in the world. We just celebrated our 40th anniversary, had a great party. It was a lot of fun. And the firm truly does still practice as what you may find to be a dying breed of law firms in New York. We are a boutique firm. We're not very large, but our practice is very heavily weighted toward environmental law, land use law, real estate, and related types of matters. Almost everyone in the firm litigates, and I'm going to talk with you about that shortly, what it means in the practice of environmental law. And in a moment, after I give you a little bit of my background, I want to discuss with you some of the different aspects of environmental law, because environmental law is not just one type of subject area, and it doesn't have only one purpose. It is not only about saving the environment, however you may define that in your moments of idealistic fervor. There's a lot more to it, more complexity to it than that. And I dare say if you take an environmental law class, you will find that someone who saves something somewhere, if you look at it in a systemic way, always produces a pressure for change and environmental degradation somewhere else. So we live in a closed system in this world where population is growing, resources are diminishing, and therefore it's a question of which environments get preserved for whom, to what extent. All right? So we'll talk a little bit about some of those aspects of environmental law and how it affects your career, especially if you're going into it with the idea that you're only going to do good for however it is you decide that, or whatever you decide good is. All right, a little bit of background about me. I am a Brooklyn Law School graduate. That's right, for those of you who don't know me. I also am an adjunct professor here. I teach land use law in the spring, and I'm teaching real estate practice in the fall. Always at 8 o'clock on Thursday nights, so you have to be committed to want to take my class. It's not the most convenient time, but it does work for me. When I was graduated from Brooklyn, I came out in a little bit of an unusual fashion. Some of you may find this relevant, some not. I was at Brooklyn Law School for a total of 5 years. That's right, not just 4. Yes, I was a part-time student, as well as pursuing a joint degree in urban planning. And I believe that joint degree program is still around, as far as I know. That served me very well, because when I came out of law school, I immediately took the New York bar, and then 4 weeks later drove out to New Mexico, where I lived for the next 8 years. Took the New Mexico bar in the following February, and practiced law in Santa Fe, New Mexico for 8 years, which was a pretty fine place to start. I was the general counsel for an organization called the New Mexico Municipal League, which is the Association of Municipalities in New Mexico. And I anticipated doing a lot of local government law work. Little did I realize that what I would actually be doing was far more, or I didn't realize just how broad a field local government law is. And I started doing environmental law, land use law. I started a self-insurance pool. I knew nothing about insurance. This was during the liability insurance crisis. I traveled all around the state teaching people about election law, learning how to do elections while I was teaching municipal clerks about election law. I did more training programs than you could possibly imagine. I started training the municipal judges in New Mexico who were non-attorney judges, which is very common in small municipalities, and particularly out west. The long and the short of it is that I gained a fair amount of experience, but this is the God's honest truth. When I came back to New York in 1988, I learned more about really being a fine attorney in the first 2 years I was back in New York than in my prior 8 years in New Mexico. There is, call it what you will, a more aggression, if you want to call it that. There is a higher level of quality of practice across the board, and there's more pressure on lawyers here in the East, or at least in New York, than there was in New Mexico. When I came back to New York, Dan Rizal of Sive Paget Rizal and I met, and we talked, and I told him what my financial obligations were, and so we couldn't come to agreement on terms. They wanted to hire me as an associate, and that just wasn't going to work out. By that time, I had already been named partner in my own firm in New Mexico, and I had been in practice on my own as well out there, and so we just couldn't come together on dollars, which was probably the best thing that ever happened to me, because I then became of counsel to Sive Paget Rizal. I then became of counsel to another law firm, and then yet enough counsel to a third law firm, and then I decided that being so independent wasn't necessarily worth it, and so I became a partner at Sive Paget Rizal about a year ago, and still I'm of counsel to these 2 other law firms. And in my practice, what I tend to do is litigation in land use law and in certain aspects of environmental law, as well as litigation in commercial real estate and other kinds of commercial transactions. Now, a little bit about what my area of environmental law is and what it involves. Since most of my work involves land use and zoning and large projects of different types, whether representing citizens groups and opposing them, municipalities, and determining how to review them, or developers and trying to get them approved, the aspect of environmental law that most comes up in my practice is the environmental impact statement. The other area of environmental law that is the largest area, which others will talk about, I think, more extensively than I, is the area of enforcement, literally environmental cleanup and so forth. And occasionally, I will be dealing with a dirty site, a schmutzy site, to use the Yiddish vernacular. And that will fit into the environmental impact statement, but it is generally not the primary focus. What I'm dealing with is what are the traffic impacts? What are the impacts on neighborhood character of a proposed development? What are the air quality impacts, noise impacts, and so on down, geological impacts, hydrological impacts, and you can go on down the list, endangered species, et cetera, et cetera. That is an area which, interestingly enough, generates a lot of activity at the administrative level. And then when you get these cases, let's say that there is a development that has been approved and a community group wants to challenge it, or there's a development that's been turned down and the developer wants to challenge the denial. The environmental issues get litigated, but they tend, believe it or not, to take second place to the land use and zoning issues. The record forms a substantial part of what the courts review in these cases. They are not generally cases that are tried before a jury or tried before a judge, where there are a lot of witnesses called. It's almost all on the record, and so therefore, and this is my first tip to you in terms of law school, you must, regardless truthfully whether you're into environmental law or something else, you must take administrative law before you leave law school. It is absolutely essential. There is no body of law that you will practice in. I defy you to come up with any one that does not have a substantial amount of administrative agency practice. Even personal injury law, workers' compensation, a lot of it is administrative in nature. So there is a tremendous importance to that. My other advice to you is that you have no idea how much every area of the law touches every other area. I could give you example after example, but it would either bore you or you'd think I was crazy. There is nothing that doesn't touch anything else. Therefore, it is essential that when you're in law school that you touch all the basics. There's a reason why before schools decided that they were going to become very, very, very free and let students choose whatever they wanted. And I say this as a student who remembers very, very well that process. The bottom line is that I didn't know then and you don't know now exactly the choices of courses really to take. You can find a great number of interesting courses. You can take law as an instrument of understanding the great philosophers of the world, or whatever incarnation of those courses there are. You will be far better served by taking as many basic bar review classes as you can. And by that I mean corporations, tax, all the courses that you may find to be either dry or boring. If they're dry and if they're boring, chances are they're important. All right? Evidence, con law, without a doubt, is a requirement. Which is ironic in that environmental law, land use law, real estate practice, the courses that I'm either involved with peripherally or directly, are second-tier courses. You should understand that. Get your basics down and then factor in which second-tier courses you're going to take. I guarantee you, you will benefit from it when you leave school. And there's just no doubt about that. The other thing I would impart to you is my bit of wisdom is litigate, litigate, litigate. Learn how to litigate. Even if you don't think you want to be a litigator, either get a job as a summer associate if you can, try to make your first job if you can't, involved in some way with litigation. Now, why? I find, this is my own personal belief, that among the lawyers that I have known who have not litigated and those who have litigated, the ones who have litigated have a sharper understanding of where the pitfalls are. You don't know how many times my real estate practice colleagues who would not set their feet inside of a courtroom short of being dragged in, and I know a few of them, who turn around in response to my question of, well, why did you do this? This is the way it's done. I said, well, this may be the way it is done, but this is not the way that the courts are going to rule on the way you think it's done, meaning that the judges go by the law, not necessarily by the custom and practice among people making handshake deals inside a closing. All right? So if you want to sharply analyze what's going on and really develop a skill for avoiding problems before they come up or seeing them on the horizon, I dare say your analysis will be sharpened by your experience in litigating, because you will see what goes wrong and how it plays out in the courts. The transactional work that I do, and I do some of it, I haven't done as much recently in the past few years as I had done in years before that. I tended to be brought into deals when they were about to cave. Either there was some really bizarre problem, or the litigator had to come in order to gong people on the heads and make them act more reasonably. That's how I tended to get involved in transactional processes. But in so doing, I came to have some experience in some very large transactional real estate deals. And since this is both environmental and real estate, let me take just a few moments to talk about real estate practice, because it is a little bit different. The one major difference that you'll find in a real estate practice is that it's not entirely, but almost entirely between private parties. There are aspects of public real estate and public real estate finance, but the vast majority of it that's practiced is between private parties. Yet your requirements of knowledge of governmental programs and of various aspects of law that involve more governmental activity, like environmental law and land use law, is key, especially if you are doing things beyond simple co-op, condo, or home sales. If you're involved in any kind of commercial real estate development, if you are involved in any large-scale real estate transaction where there could be a change in use involved or a proposed development involved, you will need to know environmental land use law. You will find in the real estate world things are a bit more specialized in certain respects than they are in the environmental and land use world. Environmental law hasn't been around quite so long. It's starting to mature now and to get specialized now. You'll find that there are people that specialize more in enforcement versus more what I do, which is the environmental impact statements. But in the real estate world, you'll tend to find that there is an even greater specialization. There are people that almost confine their practices to landlord-tenant law, some of it very sophisticated landlord-tenant practice. There are people that will confine their practices almost entirely to real estate closings and so forth. And then there are other practitioners that almost entirely confine their practice to refinancings, large commercial transactions, sales of office buildings, and that kind of thing. And then there's a group that does a lot of the real estate development work from the real estate practice end. There's more opportunity in New York statistically in terms of number of lawyers that are out there in the real estate world, and there is in either environmental or land use. You will be shocked, and I really mean this, you will be shocked to find out that the land use and environmental law bars in New York are relatively small. These are not massive numbers of attorneys the same way there are in personal injury firms or real estate firms. So if you're thinking of this, please understand that it is a sexy area of the law. There's a lot of competition in terms of getting in. Our firm, and I have done my best and continue, we hire, and we have hired out of Brooklyn, but when we interview people, it's a small firm, it truly is a boutique. We are literally taking people from the top of the top. We will have more, believe it or not, more liberal policies for lateral hires than we do for people coming out of law school. When you come out of law school, your background is your academic career. That's basically it. If you want to differentiate yourself from your colleagues, let's say you're not graduating in the top 1% of the class, then you have to do something like what I did. I didn't decide to go get a joint degree simply because I was a professional student and decided that paying tuition was fun and going to school longer would be great. I realized that I wasn't going to graduate at the top of my class. And guess what? I didn't, okay? But I did fine. And when I came out with a background both in law and urban planning, it made a difference. It made a difference when I went out to interview, okay? So I encourage you, along with taking your basic courses, differentiate yourself from your colleagues if you can. You do that by employment, you do that by volunteer work, you do that by writing. You can write articles, you can participate with others in writing articles, you can volunteer to help professors write articles, you can even write articles that can find their way into the New York Law Journal. These are the ways in which you will differentiate yourself. And the only other point that I would make is if you have a substantive skill, let's say you happen to have been a very adept at chemistry or biology or any substantive field at all. Well, law is a how-to course. It's how to, and by the way, in law school is how to learn how to be a lawyer. You won't really learn how to be a lawyer until you get out of law school. And you'll be mentored, hopefully, by someone who will really help you truly understand the practicalities of it. Now you're learning how to learn. You've got to get that basic knowledge. In doing this, when you go through this process in this way, and you work through your basic courses, you do your volunteer work, or you do something else and you differentiate yourself in some way, or you bring a substantive skill to bear, you're showing a prospective employer that you have something more to add than merely an academic resume or an academic set of credentials. All right? And I found that that was something that worked very well for me. And the only other point that I would make in that regard is nothing is irrelevant. one of the firms that I became of counsel to, I became of counsel because I litigated a noise dispute, which is an area of environmental law. And the reason that I got this case was because my family's business is in the heating, ventilation, and air conditioning industry. And so I knew the air conditioning equipment better than the mechanical engineers that were called to do it, which was really kind of funny. And so here I am as a lawyer handling this case, but knowing the area because I grew up in the ventilation business. So there is nothing in your lives that is irrelevant. You can tap into everything, and you can make lateral moves, particularly if you have strategically placed your first employment and supplemented it with things that are of interest to you in your subject area, so it doesn't make it look like you're leaping from SEC work, to dealing with PCBs in the water. You control that because you can control the other things that you do in your life besides your day-to-day employment. All right? So those are my random thoughts. I hope that wasn't too long. And I'll answer questions whenever that comes.
Thank you, Steve. And I'd just like to second a couple of things. One is that environmental law tends, in many instances, to rely upon facts. And if you have a capacity through other training to identify particular facts, that's a great assistance. Also, in relation to litigation, and one of the suggestions I always have for graduating students, if they're interested in pursuing an active career as lawyers, I suggest that they try to avail themselves of opportunities in the courts. Either if they're able to get a clerkship, that's wonderful. If they're able to work a year or so in the courts and just see how the court sorts through the factual turmoil of a case and puts it into a format upon which decisions, or the court is going to make decisions, that to me is extraordinarily valuable, because that identifies how the court in fact is going to resolve your dispute. The other aspect which I'd like to emphasize is in real estate law, it's not the worst thing if you're in small communities to become involved in politics. And that means that you may only win 50% of the time. But if you have the perseverance and the ability to oppose people but still to work with them, it is amazing how some people are able to accomplish the results and the same facts that others are not. And that, in a way, relates to being collegial. It perhaps relates to political relationships, but as a fact, it does exist. And with Steve, we had really the founder of, in his firm, the founder of the environmental law practice, and with Lee Spielman, we have that magnificent agency which maintains the national environment, the Environmental Protection Agency. So Steve, Lee, if you could share your thoughts with us.
Hi, good evening. I'm speaking here as a private citizen, not in any official capacity representing EPA. And my views are not necessarily those of the agency, but I will try to give you a few insights into what we do at EPA and how, if you're so interested, how you could get a job either at EPA or in general a government agency. What I'm involved with is civil enforcement of various statutes, and any of you who've ever taken environmental law or interned with us, you know the alphabet soup in which we live in. TSCA, Toxic Substances Control Act; RCRA, Resource Conservation Recovery Act; EPGRA, which is the, it's the the Community Right to Know Act. Some of the other statutes are the Clean Water Act, Clean Air Act, of course CERCLA, which is Superfund. So we're involved with the civil enforcement of that, of these various statutes. The tool with which I'm mostly involved in is the issuance of civil administrative complaints These are complaints that are adjudicated in Article I courts, administrative courts. They're not your regular federal Article III courts. Congress essentially is said to speed the process up so you don't go through the elaborate discovery mechanisms. You go through these specialized courts, environmental courts. Excuse me. Of course, some cases do go into federal court, in which case then we work in close hand-in-hand relationship with the Department of Justice. We also have the criminal side. Obviously, for constitutional reasons, you cannot adjudicate a criminal proceeding in an Article I court. Those have to go into the Article III. Again, the regular federal courts in that case, the agency works very closely with the local U.S. attorney's offices. Most cases that we prosecute, again, I'm talking civil administrative cases, they're settled. So a lot of my practice at EPA involves negotiating with parties. That's oftentimes where our creativity comes in. There's something called, again, if you've interned with us, you know the word SEP, the acronym SEP, a Supplemental Environmental Project, where in exchange for lowering a potential penalty, you get a respondent, an alleged violator of various statutes. You get them to come up with something creative that'll help the environment. Of course, we have guidelines pursuant to which we have to adopt these SEPs. Essentially, there has to be a close nexus between the alleged violation and the project that is coming up. That's often where we can have the opportunity for maximum creativity. Excuse me. There are, however, similarities with what we do and what one would do in federal or as well as state court. There's an extensive motion practice, and for example, summary judgment is essentially a mirror image in the administrative arena as it is in the federal court arena. That's just one of many motions we engage in. We have our own rules of procedure. EPA, it's 40 CFR Part 22. As well, we're involved in drafting orders, some of which are unilateral and some of which are negotiated. One such order, just to give you an example, is what's known as a RECWA 3013 order, where you and a private party, let's say an oil company, will negotiate, and some of these orders can run for literally 50 to 100 pages, to do a study. That's RECWA 3013 is a study. Or you can go further and do a RECWA, what's called a 3008H order, where you not only tell them study it, but you tell them affirmatively do A, B, and C to clean it up. One of the things I'm very proud of that I did at EPA, there was an oil company, and many of these companies have plants in Puerto Rico, and there was a plume resulting from their processes that was going into the groundwater. We got them not only to study the project, but we also got them to undertake steps to rectify the problem. Of course, as well, there are various Superfund orders. Superfund is one of those statutes where you'll be lucky if you outlive your case. Let's put it that way. They're very long-lasting. And people have said, I mean, a few years ago, President Clinton in one of his State of the Union said, let's amend Superfund because these cases go on and on and on. Plus, Superfund incorporates the concept of joint and several liability that arguably, one might say, could be unfair to one who had a small role in causing the pollution, but yet that entity cannot really bear the disproportionate share of the costs. If you're interested in agency work in general, and there are some speakers here from the agencies, it's not just EPA. You have the U.S. Department of Justice, the U.S. attorneys, they have local offices. The Eastern District is right around the corner here. We and I have worked closely with people from the Eastern District, the Southern District of New York, which is just across the river of Manhattan, as well as the U.S. Attorney's Office for the District of New Jersey. There's the New York City Corporation Council. They litigate and they do environmental issues. Sometimes EPA is involved in litigation against the Corp Council. You have, and I believe we have a representative here of the New York City Department of Environmental Protection. There's the counterpart state agency, DEC, Department of Environmental Conservation, that has a local office in New York City. And as well, there is the state attorney general has an office in New York. If you're interested in going and doing policy work, then I think probably you would have the most number of opportunities if you went to EPA headquarters in Washington, D.C., where sometimes seems what they do is they create these enormous Federal Register rules. I happen to have been peripherally involved in the amendment of the PCB rules. Those rules run for literally hundreds of pages in the Federal Register, but there you can have an actual input into policy. And there is where our previous speaker said, if you have a background, let's say in science, that would be most helpful, because many of these rules are written with a maximum input from scientists, engineers, and oftentimes you wonder, maybe they shortchange the legal side of it. If at DOJ, by the way, if you go to Washington, the Department of Justice, Justice itself, you have trial attorneys, you have appellate, a specific section for appellate litigation, as well as defensive litigation when, let's say, EPA is sued. Either they claim we're not enforcing the regs, we're improperly enforcing them, what have you. You have the defensive litigation section. One avenue, if you're looking for jobs in government agencies general, I don't know if any of you have ever heard of the Green Book. It's a small book, but it's very thick. It's about yay high. If you can get a hold of it, it has the names of all the agencies in New York City, including those involved in environmental matters. Plus, it gives you phone numbers and contact numbers. It's a really helpful thing to have. In addition, you have all these private non-governmental agencies. You just use the internet. We have a representative here of NIPERG, NRDC, Natural Resources Defense Council, the Environmental Defense Fund. You can go on and on with all these various groups. If you're looking for agency work, let's say with EPA, and if you're looking for the, quote, traditional environmental, like working to save forests and save animals, that's not our bailiwick. That would be other federal agencies or groups, let's say, such as Sierra Club or Defenders of Wildlife. We deal with more, as I said, TSCA is toxic substances, included under the jurisdiction of TSCA PCBs, polychlorinated biphenyls. We deal with RCRA, the Resource Conservation Recovery Act, that's solid waste and hazardous waste. If, by the way, you apply for government, one caveat, don't be disappointed if you don't get in right away. First off, there are hiring freezes. Right now, I believe, I could be wrong, but I believe there's a hiring freeze for EPA attorneys. It all depends on the vicissitudes of the budget, what's going on, battles between Congress and the executive branch, et cetera, et cetera. So oftentimes we have to reject quite qualified applicants simply because we're not hiring at the time. My advice there is just be persistent, just constantly follow up. Personally, I worked in private practice a couple of years before I went to EPA, and some of my practice were involved in asbestos litigation. And I definitely agree with the previous speaker. I think the best thing you can do for yourselves if you want to go into a government agency is if you cut your teeth in litigation at a private firm, especially, maybe I'm biased because I'm from New York, but in a place like New York City where it is kind of hard-edged. If possible, try to get an internship. EPA offers internships. I would bet that most of the agencies here and probably non-governmental agencies all offer internships. Unfortunately, the quid pro quo is many of these places do not pay you. I realize, the realities of it. But I would say pursue an internship. Another thing the previous speaker mentioned that I would like to amplify is write an article. One of the criteria we look at when we interview, are you interested in the environment? Sure, anybody can say I'm interested in the environment, but basically prove it. I mean, call it for what it is. If you can write an article, whether that's for a law review, an environmental journal, or even on your own, and attempt to get it published, why not? Sometimes interns will say they're looking for, let's say, topics. I would venture to say go to any Supreme Court opinion, environmental or what have you. Invariably, they will drop a footnote. Well, we don't touch this issue. That in itself is a law review article, because one day down the road, that issue that they're not touching today will become a matter that they're contesting. You want to have a little fun on Lexis or Westlaw? Take any environmental issue. See where the circuit courts have split. Right there, that's an issue that eventually will be resolved in the United States Supreme Court. Get involved in things like environmental moot court. I happen to be a judge at the PACE National Moot Court Environmental Competition, and I'm wondering, maybe you can educate me. Does Brooklyn Law School send a representative? If not, the next logical question is why not? I think it's a great opportunity to demonstrate your commitment, to cut your teeth in environmental litigation, and I think it presents a wonderful opportunity just to get a feel of what it's like. I strongly recommend if you can field a team, by all means do so. The next competition is coming up in February. It's third week of February. I doubt if you don't have a team this year, I doubt you can put one together in the next few months. But if you're interested, give the Pace Law School a call and find out what it takes. Some of the courses to take. Again, the previous speaker mentioned administrative law. Administrative law is literally the sine qua non of our practice. I mean, that's the nuts and bolts. But there are other courses, I think, that have relevance. Bankruptcy. A lot of companies, especially in the Superfund area, a lot of companies are going into bankruptcy. They will file. The filing of the petition, what effect will you have if you want to enforce environmental, if you're making a claim to enforce an environmental statute or its regulation? So I really want to emphasize bankruptcy is an important course. Some course that reflects my own bent, but I would recommend federal courts. Get an idea of the balance between the Article 1 courts, the executive courts, such as the EPA tribunals, and the regular federal courts. Just as a footnote to administrative law, probably the most important statute with which we deal, a general rule, a general statute, I'm not talking about a specific environmental statute, is the Administrative Procedure Act. That one statute is really what most of administrative law is built around, and I cannot overemphasize the importance of that one statute. Our rules of procedure, when I mean our EPA, is a 40 CFR Part 22. For those of you who've interned with us, you probably have at least a passing familiarity. You also know that Part 22 has a lot of gaps. Of necessity, as well as our higher appellate tribunal, the Environmental Appeals Board, has said, if there's a gap, look to the analogous or the corresponding federal code, which means Federal Rules of Civil Procedure, Federal Rules of Evidence, and Federal Rules of Appellate Procedure. I cannot stress enough the importance of having a good grounding in basic fundamental lawyering, specifically procedural law and jurisdictional law. I'll throw this out just for you to think about. If anyone wants the answer, if you want to see me later. Every year, the interns whom we employ, I ask them, can you tell me the difference or the consequences of when you're in the U.S. Supreme Court, you'll sometimes see appellant/appellee and sometimes petitioner-respondent. When you're in the circuit courts, again, I'm talking only federal, not state, some cases say appellant versus appellee, some will say petitioner-respondent. Basic procedural, jurisdictional, however you want to phrase a question. What is the difference in the use of those terms? In the U.S. Supreme Court and the federal circuit courts. If anyone's interested, I'll be happy to tell you later. Many of the questions that we address at EPA, they have echoes in almost any area of law. Was an appeal timely? Did the appellate court have subject matter jurisdiction? Is an interlocutory appeal appropriate? If so, why is it not? Would it not be appropriate? Did a respondent exhaust his or her or its administrative remedies? And of course, the essential to all lawyering, construing operative definitions. There have been Supreme Court cases just on the record question, was it a solid waste, was it a hazardous waste? If you want to see a labyrinth definition, I recommend going to 40 CFR 260, Part 260 and Part 261 under RCRA, Resource Conservation Recovery Act, the definitions of what's a solid waste, what's a hazardous waste, and the exemptions. Some of the questions at EPA that we have faced, and I've been involved in this myself, do our rules, do the EPA rules, and sometimes the state rules, because under RCRA, EPA can enforce state law. Do those rules provide adequate notice to a party of what was prohibited and what was allowed? Does the notice go far enough that if the party did not follow those rules, can we then seek a monetary penalty against that party, or would doing so violate that party's due process rights? In what case can in what kind of court can a specific case commence? If you look at TSCA, compare it to RCRA, compare it to EPGRA, each has its own specific provisions as to where EPA can bring a case. A question that often comes up under the APA, what constitutes final agency action? Important for triggering one's rights to an appeal. Another question. If the statute provides a mechanism to have federal court review, a separate mechanism saying if you do A, B, and C, you can then go to a circuit court or a district court, does that somehow short circuit or preclude a party, if they don't follow those conditions, from them then taking the standard route of review in the federal court, the APA? If a federal court, an Article 3 court review of agency action is required, a final agency action is required, does that requirement flow from the Due Process Clause? Does it flow from Article 3? Or in general, the whole concept of separation of powers? These are some of the questions that we have faced. If you're looking for standard litigation, I'm not sure that an agency practice is what you're looking for. If, on the other hand, you want to balance, let's say, motion practice with occasional hearings, with negotiations and settlements, then I think you'd be quite interested in working, let's say, in a regional office such as EPA. As I said, policy, we're involved, we have an input, but we're not the primary source. That will come more, headquarters will take the lead on that. I don't want to take too much time because there are other speakers. I'll be happy, anyone, either on the panel or later, to answer any questions. So, and please feel free to ask any. And out of curiosity, if anybody does, if you think you know the answer, the appellant, appellee, petitioner, respondent, I'd be curious to hear, because so far, all the interns whom we have had are batting zero.
Well, as Lee has made clear, the Environmental Protection Agency is surely a source for opportunities in gaining experience, and he's a marvelous representative of that agency. And in keeping with what Lee said in identifying other agencies which provide excellent opportunities, and these opportunities really relate to understanding how, in fact, disputes or policy matters are resolved. And whether or not they're resolved correctly or not is one issue, but also the process of resolving them is very important. And EPA has their manner or process of addressing issues, and then other agencies have their manner of addressing issues. And Simon Wynn is from the Attorney General's office, and the Attorney General's office has done a wonderful job in our state, really historically. It's always been a very strong advocate of the environment, even going back to the 1970s, where they intervened in the National Gettysburg Monument case. Mr. Wynn?
I hate lecterns, so I'm sorry. Thank you very much to APRA and the Environmental Law Society for inviting me to come here. I just want you to know that it's a real honor to be able to speak to you, students who are interested in following what I think is perhaps the most rewarding legal career that is imaginable, and that is a career in the public service, which all environmental law winds up being. The practice of environmental law couldn't be more interesting, because there isn't really an environmental law. It's a tremendous variety of areas of litigation, administrative law, science, risk management, and straight out and out negotiating of deals. I want to just start, though, by saying that you probably gather that I'm not a graduate of Brooklyn Law School. However, I want you to know that there's a small pocket somewhere out in deep Brooklyn where everyone speaks with an Australian accent. And that's where I come from, that little pocket. It's only 2 blocks, but it's a good block, and they only serve Foster's beer there. And in saying that, I of course am speaking like Lee personally and not as a representative of the Attorney General's office. The AG's office has a strong environmental protection bureau. In New York City we have 16 lawyers and 5 permanent scientists who are on staff. That's a wonderful resource for the AG's office. We have toxicologists and chemists, geologists, biologists, and one person who started as a geologist but is in fact the computer and graphics person for the office, who produces the wide array of maps and those kinds of graphics that we use a lot in our litigation. The AG also has an Environmental Protection Bureau in Albany, which is roughly the same size. So when you join the AG, there's about 16 lawyers here, 16 in Albany, and then we have a small group, presently 3, in our Buffalo office. That's a pretty small contingent, and I have to tell you right off the bat, so that you can feel free to go to sleep for the rest of what I have to say, that the AG does not hire anyone directly from law school. You have to be out 2 years before you can join the Attorney General's office. By the way, that's across the board. It's not just the Environmental Protection Bureau. General litigation, prisoners' rights, whatever it might be, you have to have 2 years experience outside of law school before you can join the AG's office. However, I, with another assistant in the office, run the Environmental Protection Bureau's intern program. And some of you have worked with us in the last year, and we've had a long experience of having summer and fall and semester interns in the office. We use our interns to a tremendous extent. In fact, I think it's fair to say that the last 3 pieces of written work that I've done have all been done by my interns. It's been wonderful. And they're so much better writers than I am. I just can't wait for them to come back and every couple of days when they come in and see what they've produced. And they have produced some really, really extraordinary first-rate work. So please, if you're interested in interning, either for credit during the semester or during the summer, we do have a couple of paid lines, although you probably noticed the report in, I think it was in Saturday's Times, that state tax revenues in the last quarter were down 28%. So I don't know how much longer we will have paid lines for interns, but hopefully that we will still. But if you're interested in either working for credit during the semester or over the summer, sometimes you can get federal work-study programs or some other form of credit. We'd love to have you. We've had great experience with our Brooklyn Law School students. And it's fair to say that as both Steve and Lee have mentioned before, your experience outside of law school is very important in getting a job in environmental law, because the jobs are few and far between, I have to tell you. That the experience of having an AG internship on your resume is that will stand you in very good stead. The office is known very widely for having the highest possible standards. I would say that it's definitely comparable to the U.S. Attorney's Office in that regard. And unlike the U.S. Attorney's Office, and I can say that because there's no one from that office here, you'll actually get to do a lot of real hands-on stuff, including producing written work which will be submitted to courts. I mean, my intern at the moment from New York Law School is writing an answer in an Article 78 proceeding which is going to be submitted next week. And she's writing it. I'm not writing it. I don't have time. I'm too busy coming to talk to you. So by all means, apply. I've got a few business cards. If anyone wants to call later, you can always get us through the career placement office. We've got good connections there, and I really urge you to do it if you possibly can. You'll hear shortly from Dave Rubinton from DEC. They also have internships. I won't say anything he's going to take any of his thunder, but that's also another wonderful place to get some real practical experience in the practice of environmental law.
And if you could do both, that's best.
And if you could do both, that's better still. In fact, I know there's just at least one person here who has in fact done both, and did a great job in all areas. Now, just before I talk a little bit about my background and what I do, I just want to tell you all that I have no idea what the answer to Lee's appellee and petitioner question is. So thank God I'm not likely to practice before the Supreme Court of the United States anytime soon. But you know what? You'll always be able to work out an answer to those questions if you just keep a cool, analytical head about you. And as Steve said, and I couldn't possibly agree with him and with Lee more, do the basic drudgery background courses like bankruptcy, like administrative law. I mean, frankly, as a course, it sucks. But it's going to, I mean, let's be serious. It's a very tough course to take. It's not very intellectually engaging, but you have to learn that stuff. You absolutely have to learn it, because in practice, that's the one area where you need to have some core knowledge so that the mentoring process that Steve so correctly described can build on a foundation. I know this very well because I didn't have any of that foundation. I, of course, was an Australian law student. I graduated from the University of Melbourne in Australia longer ago than I want to think, and wound up coming to New York to take a job studying organized crime. Met my wife. I planned to stay here for only a few years, but I met my wife. She's a Brooklynette, and so we never went back. And so I wound up sitting the bar and taking the Barbary course. And yes, Australia has a common law jurisdiction, so an Australian degree is recognized here. And I wound up being in private practice for almost 20 years, largely in commercial litigation, real estate, and administrative law. I had a small but highly lucrative specialty in administrative law, representing candidates for appointment to the New York City Police Department who had been denied appointment on the grounds of psychological unsuitability. We called them the PKC cases, which stand for Psycho Killer Cops. And for many years after starting that practice, every time some poor person would be gunned down on the streets by a police officer, and I'd see the headlines, I'd shut up, getting to the name of the officer who'd been arrested, who was responsible. But I'm happy to say that although I did 1,000, and I'm not kidding, 1,000 of those cases, and got many people who had been woefully discriminated against on the basis of gender, marital status, and color, above all, since psychological unsuitability was used by the police department many years ago as a simple way to get rid of people that they did not want. I'm happy to say that of those 1,000 cases, not one so far ever was involved in such an incident. And in contrast, every now and again, I'll be stopped on the street literally by some lieutenant or captain who remembers that we did their case 15 years ago. After spending a lot of time doing that, I decided I wanted to do something I felt a little better about. And so I'd always been very interested in environmental law, and decided that that's what I wanted to do when I grew up. So I went back to law school, to Columbia Law School actually, and did a master's that took all the environmental law classes that they had. That included a bunch which frankly weren't very useful. International environmental law is an interesting area, but unlikely to have much in the way of real relevance in what you're likely to do, since there really isn't any international environmental law. But procedure, science and the law, and understanding of not science per se, but the way in which science intersects with law is really worthwhile. I took courses which included some in the Department of City Planning, and those were really terrific. State and local government law, administrative law, of course, that's why I know how boring it is and that you just have to go through it. And I was lucky enough to have at Columbia a bunch of really wonderful adjunct professors who, you know, just like Professor Camming, who, and you have a number of them at Brooklyn, I know, who can be very useful when it comes to your furthering your career. One of them was Peter Lehner, the chief of the Environmental Protection Bureau here in the city, and it was through that connection that I was able to secure the job as Assistant Attorney General. So that obviously a little different to the normal assistant, since I had already 20 years experience in largely litigation, but it points out that the connections that you make here in school are very, very important to the pattern that your career may wind up taking. And so always look at who the adjunct professors are and see who might not necessarily be useful themselves, but they can introduce you to somebody that will be very useful, because your adjuncts are really, really an important resource for you to use. I'm going to be real quick and sum this up in a couple of minutes. The Environmental Protection Bureau of the AG's office is a fascinating and wonderful place to work. We not only represent the people of the state of New York in affirmative litigation, going out after environmental evildoers, if you like, but also we represent the state of New York when it is sued for environmental evildoing. In other words, we represent DEC, where Dave Rubinton it works, when somebody alleges that they are aggrieved, always incorrectly I might add, by some action that DEC has taken. And so just to give you an example of how this works, only a few blocks from here is the Brooklyn Navy Yard. And at the Brooklyn Navy Yard there was a ship repair business that routinely sandblasted and spray painted sometimes huge ships, and had no, and I repeat, no permits of any kind to do any of that from any state or city agency. We did find that they had a permit from the New York City Fire Department for a fire extinguisher, and that was it. Other than that, they would bring in these enormous ships, and I'm talking about really big ships, sandblast them completely unprotected, with sandblast grit thrown into the air to the detriment of everyone who worked and lived nearby, then spray paint them so that people had to, with completely uncontained equipment, so that nearby workers would be driven from their workplace, and poured enormous amounts of pollutants into the East River. We brought an action in state Supreme Court here in Kings County, claiming violation of a whole bunch of state environmental laws and also federal laws that Lee was talking about just a few minutes ago, specifically RCRA, for generating hazardous waste at the site. And we got that facility shut down, and it's now completely shut down, and they've moved out of the Navy Yard, no longer in business. Right after that, that was a great case, affirmative case, felt good about it and all the rest of it. Right after that, almost my next case was to represent the state DEC, who had given a permit to a electricity generator that wanted to put a gas turbine generators on a barge in the very self-same Brooklyn Navy Yard. And a citizens group, some of whom were the very witnesses we've used in the case against the ship repair business, a citizens group felt that that permit should not have been issued and brought action in state Supreme Court to get that permit rescinded. So now the AG takes off their, now we're going to do, environmental affirmative good hat and puts on a somewhat different hat. And that hat, I hasten to add, was not put on in a cynical way, like as if we felt that the position that DEC had taken in issuing this permit was wrong. On the contrary, the position that DEC had taken in issuing this permit was right. But not everyone who necessarily was against this electricity facility would have agreed with what I just said. The point is that as a lawyer, it's your job to handle these cases no matter how they fall. And you do the best that you can under all the circumstances. And I can tell you that I wouldn't have cited this case at the Brooklyn Navy Yard if I didn't truly believe, that the facility that DEC had permitted was absolutely appropriate and was the correct thing under the circumstances, because there are plenty of other cases that I could have told you about where